Good morning, everybody. My name is Councillor George Farquhar, and I'm presiding over this hearing of the Licensing Subcommittee on the 21st of July 2026. First order of business is the election of chair. May I seek a nomination, please?
Happy to propose yourself.
Thank you very much, Councillor Chapman-Law.
Second that, Chair.
Thank you very much, Councillor Bartlett. I'm duly elected as chair of this subcommittee hearing today. Housekeeping. May I call upon a clerk to read out the housekeeping notice, please?
Thank you, Chair. Please note that this meeting is being recorded by the Council for live broadcast and will be published on the Council website for a minimum of 6 months. The meeting may also be recorded or streamed for live or subsequent broadcasts by members of the public, or their ultimate discretion in this matter lies with the Chair in case of disruption. For those in the room, please note that if the fire alarm sounds, please exit the building by way of the nearest available signed fire exit route and make your way to the assembly point at the War Memorial in the gardens opposite the front of this building in Bourne Avenue. Finally, please can we ensure background noise is kept to a minimum and mobile phones and other devices are turned off or switched to silent for the duration of the meeting. This includes turning off microphones and turning the volume down completely on your laptops. Thank you.
As the chair of this sub-hearing and the subcommittee hearing, I have no interest. Councillor Bartlett, do you have any pecuniary interest?
No, none, Chair. Okay.
None, Chair.
Thank you very much, Councillor Chapman-Law. The protocol for public speaking at hearings is actually laid out in the agenda sheet and it's for noting. The item of business today is Boo Premier, 69 Bennett Road, Bournemouth, BH8 8RH. I'll ask each participant to introduce themselves and state their role at this hearing today. I am Councillor George Farquhar and I'm the chair of the subcommittee.
Councillor Steve Bartlett, a member of the subcommittee.
Councillor Chapman-Law, member of the subcommittee.
And to my left?
Andy McDermott, legal advisor to the committee.
Michelle Cutler, clerk to the subcommittee, and can I also just confirm that there were no apologies for absence this morning? Thank you.
Tanya Dean, licensing officer. Nananka Randall, licensing and training standards manager.
Andy Hill, principal environmental health officer.
Thank you very much and welcome, Mr. Hill. We don't very often see you at these subcommittee hearings. Thank you. For the applicant.
Morning, Chairs. I'm Philip Rush, applicant after this review under the sections 51 after the 2003 Licensing Act.
I understand, Mr. Rush. We're just doing introductions at the moment. I really appreciate that. And who's to your right there?
Yes, I am.
Shall I introduce myself?
Yeah, just.
Cathy
Say again.
Cathy Goldman, just partner. We live same address.
Thank you. And for the premises, please.
Good morning, Chair and members. It's Hussein Shimshek. I'm one of the director of the business.
It's Baha Bulbul, one of the premises holders. Thank you.
I'm Wayne Bradley. I'm a retail development manager for Bookers and I look after Premier Stores in Dorset, so I've come along to support.
Sorry, I'm a bit hard of hearing today. You're retail manager for?
Booker, I look after Premier Stores. Okay.
Before I run through the procedure, may I just check that all persons who have given notice of their intention to speak have been identified, and that any persons who actually wish to withdraw their representation or wishes not to speak has also been identified. See no indications, I'll take that as correct. Oh yes, just so that we're aware that this is a public meeting. It is broadcast and streamed to the public. Also in the audience we have members of the public, we have students on work experience, and we also have 2 reserve members. The 2 reserve members are to the rear there. and they will take no part in the hearing or in the deliberations afterwards. So only those individuals which I've identified and have introduced themselves will be actually partaking in speaking at this subcommittee hearing today. Thank you very much, Councillor Chapman-Law. The proposed procedure for the order of speaking in this hearing as follows. The licensing officer will present their report. There will then be questions of the licensing officer by all parties, with the members of the subcommittee going first. The applicant will then make their application. There will be questions of the applicant by all parties, and members of the subcommittee will go first. The persons representing the premises will make their representations, and once again there will be questions of the persons representing the premises by all parties, and once again the subcommittee going first. All parties will be given the opportunity to sum up, and the party who spoke last will sum up first. The hearing will then conclude, and the subcommittee will deliberate in private with the legal advisor and the clerk present. Notification of the subcommittee's decision will be given within a period of 5 working days, beginning with the day of the court. We're beginning with this day on which the hearing was held, and notification of the decision will include information about the right of appeal as appropriate. I will now ask all parties to confirm agreement to the proposed procedure or make representations to why they do not agree. Ms. Juddy.
Agree, Chair. Thank you.
Ms. McDermott.
Agreed.
Mr. Hill.
Agreed, Chair. Thank you.
Mr. Rush.
Agree, Chair.
Ms. Goldman. Mrs. Bulbul.
Yes, agreed.
Mr. Samitsky.
Everything.
Thank you. Mr. Bradley.
Agree.
May I remind all parties speaking not to repeat the information which you've already supplied in writing, but to expand upon that written representations. All questions will be asked through myself as the chair, and there will be no cross-examination of any parties. I will now ask the licensing officer to present their report.
Thank you, Chair. So this review application has been submitted by Mr. Philip Rush under Section 51 of the Licensing Act 2003 in respect of the premises licence held by Mehmet A. Bulbul, Hatis Bulbul and Bahar Bulbul for 69 Bennett Road. The review is brought on the grounds that the operation of the premises is undermining the licensing objective of the prevention of public nuisance. The premises have been licensed since 2005 and the licence was transferred to the current holders in 2013. Mr. Rush, who lives next door to the premises, states that for approximately 9 years he has experienced ongoing disturbance from mechanical plant and equipment located at the rear of the premises. His concerns relate to noise, vibration, heat and odour, which he says amount to a public nuisance. He also alleges breaches of conditions 2.14 and 2.17 of the premises licence, which require that noise, vibration and noxious smells arising from the premises do not cause a nuisance to nearby properties. Before submitting the review, Mr. Rush raised a number of concerns with the licensing authority. He was advised that several matters appear to fall more appropriately within the remit of environmental health, planning or building control rather than licensing. However, the alleged breaches of conditions 2.14 and 2.17 and any impact on the prevention of public nuisance objective were considered capable of engaging the licensing regime. Mr. Rush subsequently submitted a formal review application, and in recognition of his statutory right to seek a review of the premises licence, the licensing authority accepted the application and it is now before members for determination. In response to the application, Ms. Bahar Bulbul, one of the premises licence holders, disputes that the issues raised engage the licensing objective. She states that the equipment referred to is a refrigeration unit used for soft drinks and not solely connected to the sale of alcohol. She also advises that mitigation measures have been implemented, including relocation equipment, restricting operating times and carrying out servicing works. Ms. Bulbul has also provided correspondence from another resident living in the same building as Mr. Rush, who states that they have not experienced the issues alleged and have no concerns regarding public nuisance.
That resident has submitted their own representation, which forms part of the report pack that members have access to. Mr. Rush has submitted evidence in support of his application, including reference to noise from metal shutters. He has also rebutted the shop owner's statement and proposed conditions for members' consideration should the subcommittee decide the steps on the licence are appropriate. These are set out at Appendix 7, Exhibit E, Heading 3 on page 83. And that's part of the agenda pack, the main agenda pack. Mr. Rush has also provided video evidence that he wishes to be shared during the meeting, and I will await instructions from Mr. Rush on this. The Licensing Authority has received 10 representations in support of the premises. While some comments may fall outside of the scope of the Licensing Act 2003, they have been included for completeness. It is a matter for members to determine the weight to attach to those representations. No representations have been received from responsible authorities. Environmental Health have provided a statement outlining its historic involvement and current position. Members will note that Mr. Rush was asked to provide noise and odour logs and was offered further investigation, including monitoring equipment. It is understood that no logs have been provided and the offer of monitoring has not yet been taken up. Mr. Hill is in attendance to answer any technical questions relating to the prevention of public nuisance licensing objective. Planning enforcement has confirmed that the refrigeration equipment has been in place for more than 4 years and is therefore immune from planning enforcement action. Members are reminded that licensing and planning are separate regulatory regimes with different purposes and enforcement powers. Planning has made no representation in respect of this review. To avoid repetition, I will leave it to the parties to expand upon their written submissions and supporting evidence. Members are reminded that any steps they take must be necessary and proportionate for the promotion of the licensing objective of the prevention of public nuisance. Such steps must be directly related to the licensable activity authorised by the premises licence, namely the supply of alcohol for consumption off the premises, and must be directed at addressing the specific concerns identified in the application, insofar as those concerns are established through the hearing and having regard to the evidence presented by all parties. Thank you, Chair.
Thank you very much, Mrs. Jardine. Any questions of fact of the licensing officer, if you please, subcommittee? None. May I ask Mr. Hill, what's your role here today? I do note that the subcommittee and all applicants have read the statement from Environmental Health.
Chair, so whilst my response in relation to this application is outlined in Appendix 8 of the report, as you correctly identified, I've made myself available today to the Licensing Subcommittee to answer any questions you may have, to provide guidance to Mrs. Jardim or Mr. Rush or the license holder, to answer any queries you may have, and also to provide an up-to-date appraisal of the condition of the premises, which I visited this morning.
Thank you very much, Mr. Hill. I really appreciate that. Any further questions from the subcommittee? Excellent. Mr. Rush, any questions of the licensing officer? This is not the opportunity to present your report, simply any comments or questions which you have on the licensing officer's presentation report.
Thank you, Chair. Well, I just need to address the question about that on the licensee perspective himself. Obviously, the licensing purpose is for business only and not included any operations outside the premises. My question is why the licensee allowed or it been allowed under the environmental and planning permission to installing enormous numbers business which is running the truly the shops providing the service to the public. The number of the extractors is out of order. They don't have any planning permission for it, and also they are enormous. They are industrial size, which is in compared to the normal actual use of the ventilation or extractors. It's not related to the business and shouldn't be.
If I may just summarise, Mr. Rush, is that I think your question to the licensing officer, or indeed to the environmental health officer, is in relation to the plant, and mechanical plant and equipment which is outside. Is that correct?
This is involving the three major pillars: the licensing, the planning, and environmental. Now, environmental is running under the 1990.
Okay. Was my summary of your
Yeah.
question correct? So the plant in relation to the Licensing Act.
It is
Okay.
a relation
Thank
because
you.
they using that as an operation of the business.
I understand, Mr. Rush. So, I think our legal officer might be best placed, but environmental health may want to offer some support.
I don't know if that's a question that the licensing officer can actually respond to. It may be more appropriate to for the environmental health officer to comment on that later on. But for the purposes of, as a matter of fact, we know the premises license has been granted, and we're looking at that today. So we're looking at whether or not the licensing objectives are upheld, and we're trying to consider this review. So that's the focus of today.
So if it helps you, Mr. Rush, this is an opportunity not to present your case, but essentially to ask questions of fact of the licensing officer. So in this particular case, as regards to the Licensing Act, it's not a question that a licensing officer can actually answer because it's not within the remit when it relates to mechanical plant. Do you have any further questions of licensing officer?
I just want to reframe the explanation of the legal representative. Obviously, the licensing granted again is for a business purpose. There is no included any clue on the licensee for including in planetary anything external apart from the business himself, which is granted for business. I'm not having an issue with that. Is the questions, are they the licensee allowed any external planetary to use to operating the business? That's the question. Reframing that is different matter because I'm not asking about the grant.
Understood, Mr. Rush. We established that the license has been granted. Mrs. Jardine, can you tell us when the license was actually granted to this premises, please?
The licence was granted in 2005, apologies, and that was following the transition from justices' licences. And just for clarification, when a licence is granted, it's granted for the activities that have been applied for, not for equipment or machinery or anything of that sort. It's for the actual activities. Anything else is outside of the scope of the Licensing Act.
Does that answer your question, Mr. Rush?
Is in need to be apply for a licensee and planning permissions and environmental, and also that activity have to come on the parameters of how that activity causing any nuisance or disturbance to the surrounding neighborhood. Now that it doesn't mean.
Mr. Rush,
yes.
You understand that plant that we're talking about here, with the license being granted in 2005,
yes,
20 years ago,
yes,
that plant is not within the scope of the Licensing Act.
Well, right. The licensee granted in 2025 under the according to the company house, it was news agents. It wasn't convenience shop.
Mr. Rush, I think what's happening here is that you will have the opportunity to present your case.
Yes.
But the opportunity here is for all parties to ask questions of fact of the licensing officers. The licensing officer is here, has presented the report as you've requested for your review of the premises. So the question of fact is that the license was granted in 2005, and the plant, as you heard from the licensing officer, is not included in the Licensing Act.
I understand that.
Okay.
Yeah.
So when you get the opportunity to present your case, which will be shortly, yes, I think you might want to expand on what you've already presented in writing. Does that make sense?
Well, it does, yeah.
Excellent. Do you have any further questions of the licensing officer as a matter of fact?
No, for now.
Thank you very much. Mrs. Bulbul, have you got any questions of fact of our licensing officer, please?
No, thank you.
Excellent. So moving on with the application. Mr. Rush, this is your opportunity to present your application. I remind you, do not duplicate what you've already presented in writing, but expand on that for the understanding of the subcommittee. And the subcommittee will ask you questions upon your application, which is presented here, and possibly on what you've presented in writing. And all parties here will also have the opportunity to ask you questions. Those questions will be asked through me and answered through me. Thank you very much.
Committee. This review is brought up in pursuit of Section 51 of the Licensing Act 2003. The sole licensing objectives engage the prevention of the public nuisance. My opening will direct the committee to the statutory framework, evidential record contained within the main bundle and supplementary bundle, the environmental health investigation chain communications, and the medical impact arising from the 9 years of continuous nuisance. The nature of the nuisance, mechanical and continuous industrial long term, the fact that the main on a main bundle exhibit C3, C4, and D1 establishes that the industrial's great mechanical plant has operated daily from the 6:30 to 2300, preceding industrial's peak of the 70 to 76 dB, emanating the other eternal hum on and off cycle, vibration, and early morning shuttle impacted the noise. In sub-directed the adjacent of my residential boundary, without noise enclosures of the planning permissions. The operating is direct contradiction to the license holder. The license holder's assertion is that fans are off at 9 p.m., which is the evidence. This is not the trivial dispute. It is the presented intrusive, harmful environmental nuisance squarely within the definition of the public nuisance under the section 182 of statutory guidance. The nuisance is occurred daily and ongoing as confirmed by calibration residence measurements of the exhibits C3, Council Marathon's monitoring exhibit C4, photograph evidence of the exhibit D1, and supplementary recording submitted on 15 and 20th July. Environmental health investigating change independent verifications. Environmental health involved in it from 2018 to 2026 is documented across the bundle. In 2020, Marathon's monitoring recorded 55 to 79 and 41 noise events. Industrial picked up to the 70.2 database. Turner Humans compulsory cycling operations until 2300. The environmental has recommended relocation mechanical plants, acoustic enclosure, and planning compliance. The license holder refused. The subsequent procedural failure of 40 in regard to the 40 equipment, incompleted background assessments, COVID restriction, combined data, and failure of the investigate fume, heat, odor, or boundary instructions explain the absence of the statutory nuisance actions. They did not engage the nuisance itself. Also, the medical impact relevant to the licensing law, GPs, as stated, that California confirmed after the bundle, sleeping disorder and anxiety and anticipatory stress, fatigue, and cognitive impact after that nuisance after the 9 years period prolonged. The section 182 guidance expressly recognise sleeping disorders, persistent mechanical noise, and tunnel human relevant public nuisance is relevant to the public nuisance, and medical impact is therefore directly relevant to the licensing objective. The planning breach intensified the license breach. Exhibit D2 confirmed that mechanical plants unlawfully installed, no acoustic enclosure, no buffer zone, direct adjacent of the residential boundary, industrial equipment operating is the residential zone, continuous heat discharge and other emissions. Planning breach are relevant where they increases the nuisance, and removal require acoustic control. That is precisely the situation is here, which is obviously been told. The misrepresentation and contradiction are relevant to the credibility of the compliance. Across the main supplementary bundle, the license holder stated that fans off at 9 p.m. Soft drink refrigerator only, fans relocated, no nuisance, planning irrelevant, only one complainant, which is according to me. The evidence shows that opening until 2300, units are used for beer, wine, and alcohol storage. Original unit still is in place. Continuous nuisance from 2018 to 2026. Environmental has confirmed the relocation require planning consents, boundary exposure uniquely affecting my property, which is they are too close to the less than a 2 meter. The contradictions demonstrate the knowledge of the nuisance, failure to mitigate, a lack of the candor, non-compliance with the licensing control. The license holder's central legal error directly relevant to the determinations the license holder said, even that a bold statement of the second statement been sent to the licensee. Even if the license committee were to vary the conditions of our premises license, the refrigerator system would continue to be in use. Any changes to the license would not address the issue being alleged. So this is the bold statements by the license holder. Chair member, this statement is legally incorrect. Under the section 52 of the Licensing Act 2003, the committee may impose any condition necessary to promote the license objective, including relocation of mechanical plant, acoustic enclosure, opening hours restrictions, noise limit, maintains the requirements, planning compliance trigger, or suspension of the revocation of the license. The committee's powers are not limited to the alcohol sale. They extend to any aspect of the premises operating that undermines the license objective, including the mechanical plant. The sections therefore represent the fundamental misunderstanding of the licensing law and the creation of the non-compliance with the licensing control. Supported the statement minimal evidential weight is under the Hope and Glory and Westminster 2011s, Business Committee must consider impact of the complainants, not popularity, evidence, not sentiments, and nuisance, not the customer service. The support do not lie in the boundary of the boundary and cannot give evidence regarding the mechanical noise, vibrations, or late evening operation. Their statement carried minimal weight, which is the operation of the premises. Require condition and necessity of operations enclosed are respectfully invited the committee to impose the following conditions: relocations of the mechanical plant, acoustic enclosure achieving 15 dB reductions, operations hours restricted 2100 to 0800, shutter restrictions 2100 to 0800. Noise compliance, the decibels noise compliance restrictions, maintains and monitoring, planning compliance within the 60 days and enforcement of trigger for any breach. Thank you.
Thank you very much, Mr. Rush. May I just ask that on your proposed conditions, you talked about relocation, enclosures, and not, say again? Yes, I understand that. For the plant not to be in operation between 2100 hours and 0800 hours in the morning. I missed the line. I missed one of your offered or one of your suggested conditions. I've got noise compliance. What came after 2100 to 0800, please?
Well, second 21800 shutter restricted. The shutters restricted in safety shuttle, which is the opening in 6:30 in the morning, is a metal safety shutter. When they actually yanking the shutter.
My question was that you proposed some conditions.
Yes, this
because
is
you're an applicant here. So what I asked was that relocation of the plant, the acoustic enclosures, a restriction on the plant use between 2100 hours and 0800 the following morning. I've got the noise compliance. However, e.g. the compliance for nuisance noise and maintenance of the equipment, etc. I missed what came after 2100 to 0800 for not having the plant operation. Is that something to do with the shutter operation?
Well, that's the shutters which is.
Can you just read that line?
Yes.
Yeah, that came.
The shutter restriction 21 to 0800 is a reason and condition for that. They can use electronic or mechanical control.
So 2100 till when?
2100 to 0800, which is these are basically
0800.
Yeah, is the opening hours.
Thank you very much. Any questions of Mr. Rush from the subcommittee, please? Councillor Bartlett.
Yeah. How long have you lived next door? You've lived there for 9 years. Okay. And can you just describe the type of property that you live in?
It's a ground floor flat.
Okay.
The boundary basically is almost bad. With their extensions to the main building is close to the 2 meter, 1.5, 2 meters. The main wall of the building to my garden and my patio door.
Okay. So
basically, the building facing their buildings facing that way, my property facing this way, which is my garden is here, the patio door is here, and their buildings over there, and which is the main fence causing the nuisance, is direct located to my garden, and with the distance of the 1.5 meter from my patio door.
So you've already answered one of my questions, is do you have a garden? Presumably the noise that you hear is throughout any position that you're in the garden.
It does make any difference what I try. I actually use a headphone recently because it's unbearable. As I said, there's the 9 years of suffering and the medical examination, obviously, after the anxiety and distress I'm facing with, is no way out because there is no, obviously, consideration has been taken on board, basically to reduce the work together as a community and respect the right of the next door neighbours.
Okay, so when you moved in 9 years ago, how much of that industrial plant, as you call it, looks like air conditioning or extractor units to me, how many of those were there?
Oh, actually, when I actually moved in, I didn't notice that because there was a winter, like autumn time, which is there are, as they call, condition, and the fans are normally off, which is that's called like a seasonal nuisance. And in regard to that, when the summer 2018 basically start noticing the noise, my first complaint to the council, the environmental, I noticed there is almost about 9 extractors fans is located like between 2 buildings, circling all the way from the east side of the building all the way to the west and north position of the building. So basically there are 9 extractor fans was there, and they were operating at the time. They were operating 2 unit, which is both of them was very old and smelly and smoky. And when it start on, is make a hell of a noise. With a complaint to the environmental, basically they replace the one of them, which is they put more bigger. According to them, is there less noise, but they're not in consideration of the boundary or anything and the purpose of the complaint. Yeah, they were about between the nine extracted fans, but I don't know that all of them was active at the time, or was that 2? Because my point on the point of that 2, which is direct face into my garden.
Okay, but from the photographs that I've seen, there's not 9 units there now. There are, I think, from what I could see, there are 3.
No,
three large.
They are, yeah, yes, they are. They've been after I submitted to the planning permissions. Obviously, I think the officer wrote the thing, and they removed those unused or old extractor fan. Now, it's correct. It got 3 of them in use. And basically the one which is the major complaining and issue to me, and the other 2 is toward the north side of the building, which is away from my garden, my area, and my boundary. Basically, it's still the noisy through the night, which is according to them, one of them running for a dairy is 24/7, and with a on-off switch, which is creating noise in a peak time, off peak time is during the night.
Are there any other extractor fans located on any other building nearby or adjacent?
I haven't been witness. No, I don't think so.
No. Okay. Thank you.
You're welcome.
Thank you very much, Mr. Rush, for those answers. Just for a matter of clarification, when you moved in 2018, because you submitted a photograph, yes, which is not, as I would view it, the rear of the premises, which currently has 3 extractor fans on them, coloured grey, or pieces of plant. You submitted a photo that had multiple, which seemed to be on a sidewall, which is not visible from the street. How many extractor fans were there when you moved in 2018, and how many extractor fans are there now? And finally, you said that some had been relocated. How many have been relocated, and from where to where?
Right. On my memories, obviously, I can say there were 1, 2, 3, 4, about between 7 to 8 extractors in total.
In 2018, how many pieces of plant were on that site?
When I moved in 2018, I believe so. It was about 6. 1, 2. Yeah, about 6.
And how many were on, as you describe it, the northbourne?
The northbourne is about they are after is installed. It is a 2 unit.
How many were there in 2018?
2018, 7. And not toward the north side of it. You would say about the north side.
What can be viewed from the street?
From the street is only 2 of them can be seen from the street, which is the north side of the building. And there are.
Mr. Rush, I'll ask questions one at a time, if you please. When you moved in 2018, there is 2 walls that are on the boundary of your property. Is that correct?
Yes,
Yes. The photograph that you supplied in the pack, which wall is that?
is a wall where it north,
Which wall would you describe it as? Is that the north wall or is that the boundary to your property?
is a north side of the building,
So the photograph you supplied is the north side of the building.
north side of the building, yes.
Excellent. So how many extractor plant, pieces of mechanical machinery?
6
were-
or 7. 6 or 7, I'm not exact. It
6
is-
or 7?
I think that's 6,
Not done, no.
How many are on your photograph now?
yes.
Check the thing. There's only
1, 2, 3, 4.
Perhaps the applicant can clarify how many units.
Absolutely, Mr. Hill. What I'm trying to establish is what the original complaint was in the summer of 2018, where that complaint was related to, what equipment it is that it's specifically relating to, and what wall it is on. Because what's of interest to me here is, particularly with the applicant, is the nature of the boundary and the distance from the property.
This is the
Just a minute, Mr.
sorry.
Rush. I'm also interested in the wall, which is to the, what I would call the rear of the premises. What Mr. Rush refers to that wall is how much equipment is on there. And because it's visible from the street, I've done a Google search for when plant was added to that particular wall. The wall which seems to be in question, which has been supplied in the bundle, Mr. Rush has supplied photographs of, and I'm trying to establish what Mr. Rush refers to that wall as, where it is in relation to Councillor Bartlett's point to his property, and what equipment, if any, has been moved. Can you help me with that, or would the applicant be able to help me with that?
My understanding, Chair, is that the photographs shown in the bundle are from the elevation seen from Mr. Rush's property, so from his garden. So the photographs in the bundle show the plants viewable from his garden. So if that helps if that assists the committee at all.
Would it be acceptable that you refer to that wall as the garden wall, Mr. Rush?
I'm going to reframe that, obviously, with a clear explanation.
Just one moment, Mr. Rush. Sorry.
I think in the context of if we consider the plant which is most likely to create a nuisance or affect Mr. Rush, that would be the plant that we talk about. So it'll be the plant that is directly visible from his garden. I think the plant on the side elevation of the property is highly unlikely to be audible from Mr. Rush's property. So I think the only plant we should consider is a plant that is directly viewable from your garden.
Yeah, only that one. Yeah, he's right.
Okay, I appreciate that. So that's valuable evidence as regards on the side of the property, which is visible from the street.
Yeah.
My next question to you, if you could answer me, Mr. McDermott, I'm sorry, Mr. Rush, because I'm just trying to get a little bit of clarification for what the nuisance is. There's mention of some pieces of equipment were moved, and how many pieces of equipment were moved from that garden wall?
I believe 2. Yep, 2. So in 2020, when I initially spoke to the license holder, they agreed to relocate 2 pieces of plant. Yes, and those are the 2 pieces that are now on this side elevation.
Yeah, 2. Right.
Right, so they made, and again from Google view, you can see in 2015 none on the side view. 2019 1 piece of plant which is viewable from the street, and then in 2023 3 pieces of plant. Couple look balanced on the patio. Excellent.
That's correct, Chair.
What we need to establish now is how many pieces of plant are left on the garden wall, e.g. the wall that's facing you. How many pieces of plant are there today?
Yeah.
And Mr. McDermott, did you get an opportunity to inspect them today?
Mr. Hill.
Sorry, Mr. Hill.
No. So, Chair, just to clarify, my visit this morning was I visited the licensed premises. I did not visit Mr. Rush's residential property. We have offered to visit his property, but he's declined that offer on a number of occasions. So to clarify, Chair, I did not visit Mr. Rush's property this morning. So I'm not able to confidently say how many pieces of plant are currently on his property since my last visit, which was in 2020. However, the evidence bundle, which I believe the photos are very recent, show that there's been no increase in the amount of plant from when I visited originally in 2020.
Mr. Rush, back to you.
Yes.
So on the wall facing your property, e.g. the boundary wall, the garden wall, how many pieces of plant are there today?
One massive industrial size.
One piece of plant.
Yes.
So the photograph which you showed me, what is the
This photograph shows the old ventilations. Got one here, 2, 3, 4.
I don't understand, Mr. Hill. You're showing me a picture in the bundle that shows 1, 2, 3, 4. How many pieces of plant are actually on that wall today?
Today is a one.
One. That's the problem, yeah.
The reasons.
Just one moment, Mr. Rush. I was going to ask you this question, Mrs. Bulbul. Do you know the wall which we're talking about, which is facing the property of the applicant?
Yes, I do. I think
How many pieces of equipment are on that wall today?
one.
Can you explain what's happened to the other 4 pieces of equipment, or the other 3 pieces of equipment, and if you've removed them or they don't belong to the Premier stores?
Okay. Thank you, Chair. I think
Got
it's
your opportunity for presentation.
that's
I just
absolutely
want to ask the question
that's
so that
fine.
we can
And
clarify
we've got
what we're
timeline
dealing
of
with.
what's actually been done.
Excellent.
Andrew Hill would be able
Thank
to
you.
also confirm as well. So initially, when Mr. Rush campaigned in 2018,
I have a very simple question of you, Mrs. Bulbul.
Oh, okay.
Is how many pieces of equipment are on that wall just now?
There's one.
What happened to the other 3 pieces of equipment? Did they belong to Premier stores or the responsibility of Premier stores? And if they were, when were they removed, or do they not belong to Premier stores?
So initially there were about 4. There were 4 fans on that side when Mr. Rush was first complained. Then after discussions with Andrew, we thought we believe that the dairy fan, which was on for 24 hours, as you would appreciate, we have to have it on for 24 hours because of the product's safe condition and temperature. We've moved that to the rear, which I would call the rear of the property. So that was moved when Mr. Rush first complained. Then his complaint continued. When his continued, we actually changed the dairy fan, even though it was working fine to our understanding. But because his dispute,
Mrs. Bulbul.
yeah.
What I want to ask the question, which I've established so far,
Okay.
this is not the opportunity for you to present your case at this moment in time, because I just, as a matter of fact and for evidence, you've established that there is only one piece of plant equipment.
Yeah.
I've asked you the other 3 pieces that were presented in the photograph in the public pack, which is available to everybody to look at. Were they belonging to the Premier store? And if so, have you removed them?
Yes. The short answer to your question is yes.
When did you remove them?
When he first initially complained. The ones that were
I
not
have
working
what
or
date
not
and
belonging
year,
to the
please?
property, the ones that were not working and was not belonging to property, we removed them
Mrs. Bulbul,
we removed them.
I'm simply asking the question, have you looked at the pack and the photographs that have been supplied?
Yes.
Okay, can you get those up just now? You will see that there are
The ones that I provided or Mr. Rush provided.
Well, these are taken from Mr. Rush's garden, I presume.
Yes, they are.
They show the inner corner of a building. There's 1, 2, 3, 4 pieces of plant. On the right-hand side, there is a piece of plant which is below what looks like a window. On the left-hand side, there is a piece of plant which seems to be either attached to the wall, but below it is some sort of assembly with a felt roof on it.
So poo has been removed recently because having discussions with which ones?
Premises stage management, that's all.
Yeah. So the ones that were not relevant to the premises were removed.
When you say not relevant to the premises,
The
what premises? I'm sorry, Mrs. Bulbul. Let me start again. There is one piece of equipment.
Yeah.
From the picture which is on page 73.
Can I see which photograph you're referring to? Thank you, Mr. Hill. Okay, yes.
There are 4 pieces of plant equipment there.
Yeah.
Mr. Rush, one moment. Mr. Rush referred to 6 or 7 when he first moved in 2018.
Yeah.
The evidence which is provided to the hearing today has 4 pieces of equipment.
Mm-hmm.
Which piece of equipment, you said one remains, out of that 4 from left to right, which one remains?
The one at the far
From left
end.
to right, 1, 2, 3, 4.
So, the left, first left has remained.
First left, that remains in place.
Yes.
Were the other 3 pieces of equipment the responsibility of Premier Stores at any point in time since you had your license in 2005?
Yes.
Excellent. What has happened to those?
Okay, so that's what I've tried to.
Have you removed them?
Yes.
Excellent. Which of those 3 have been relocated?
2 of them.
Which of those 3 have been relocated or upgraded? Because I'm seeing 4 pieces of equipment in the evidence provided by Mr. Rush.
Okay, come in.
Thank you.
Thank you, Chair. So on this picture, the Mr. Rush picture, there are 4 fans there.
Correct.
The first one is still on the same place.
Correct.
These 3 fans is on the bin now, so it's not related with the premises. So
they were the responsibility of the premises. Is that correct?
Yeah.
And why are they on the bin now?
So because the Mr. Sean about.
Okay, let me just basically when either replaced with new ones or relocated.
Okay, so
Does that
to
answer your
my
question?
appearance, what is on the rear of your building, 2 of those fans don't look like they're the ones that are now on the rear of your building.
Yeah, so
Okay.
we replaced them because of.
So you replace them. So they're carrying out a function.
Yes.
Excellent. When it comes to your time for presentation, I'm going to ask you what the function of each fan or extractor unit is, please.
Okay, but they were that at the time. Now they don't. There's only one at first.
I understand. So the reason why I'm pressing this matter is because we deal with evidence in this hearing. The evidence which is presented is misleading to me because it is confusing because it shows 4 pieces of equipment. I appreciate that might be in the situation when the evidence pack was put together and presented. However, what is confusing to me is that nobody seems to be able to give me a date for when those extra 3 fans were either scrapped, replaced, relocated. What date?
Can I quickly ask Mr. Rush? What
No,
date?
this is not your. Well, this is not your opportunity just yet because we're still asking questions from the subcommittee. So, if you could answer my question, because Mr. Rush doesn't seem able to, because he's presented these fans, and we now established that there is 1 fan facing his property. Okay. Mr. Hill, do you have some input as regards what's happened to these 3 fans and at what date they disappeared?
I think the applicant would know the date they were removed because it would have been fairly short, soon after my intervention with yourselves, which is in 2020, my initial intervention, which was 2020. So I believe it would have been very soon after that. I mean,
Can you confirm? Can you confirm when they were removed?
Yeah.
Yes, it was so when he complained 2000, before his complaint, so
I'm not, as a matter of fact, the question is being asked, when were these three pieces of equipment removed? Please, can you confirm what date, what year?
on this,
Yes.
yeah, it's recent.
Well, sorry, can I just interrupt? It wasn't recent, you're saying, because there were four.
Mrs. Boo, just give me 1 second. I have a suggestion from a subcommittee member here.
There's four, according to the photo.
Mr. Rush. The pictures that are on page 73 of the pack, when were they taken?
They are taken at the time of opening the dispute about the nuisance back in 2019, I believe.
Right, so these aren't, so you've presented evidence,
Yeah,
yes,
they are back in
2019. Do you have any pictures of it, how it is now? Of the same values?
Few photos is basically is the north side of the vending shop, which is installed.
No, I just want, do you have a photo of how it is now? And when did it change from what you've submitted in the pack to now?
Okay. Right, if the hearing could come to order, please. Thank you very much. If the hearing can come to order. Apparently there is a video you'd like to present, all right? We have some more questions to actually be asked by the subcommittee first, and then other members of the hearing, yes. So we will hopefully answer the question for the state of play. In other words, what the nature of the noise complaint is today for this application, which we're considering for the evidence. If we wish to show that video, Mr. Rush, do you wish to show that video?
Yes.
We will have to exclude the public. So what?
We don't need to exclude the public for that one. Sorry.
Why not?
Because it's got nobody in it. It's just the fans and the noise. So there's no members of the public in the video.
Is there any video which you wish to see at the same time, which is members of the, who has any reason to exclude?
No.
Why is it my pack that we're excluding there?
Because Mr. Rush submitted some medical evidence that had personal data on it.
Is that in the video?
That's not in the video.
Okay, right. So the hearing as a whole. Can we just come to order, please? The hearing as a whole is we will continue to ask questions of Mr. Rush. We'll see a video for what the state of play is as regards what the nature of the equipment is and where it's located in the video, which can actually be shown in public. You'll have an opportunity to ask questions of Mr. Rush after we finish our questions of the subcommittee, and we'll proceed with the hearing. Thank you very much. Any further questions from the subcommittee of Mr. Rush? Mr. Rush, may I ask you a couple more questions before we give the opportunity for the licensed premises and the licensed officer to ask you questions? So you've been in that property for 9 years in a ground floor flat. We've established that the plant was installed and that it was there and some has been removed. My question to you is, why haven't you submitted the latest information to the environmental health officer in time for this hearing? The information that the licensing officer and Mr. Hill referred to is that there were apparently some noise logs or something which were requested. And why was that not submitted? Mr. Hill, do you want to refresh us of what was actually expected to be submitted to environmental health?
Yep, so just so the committee can fully understand the position. So environmental health has indeed on a number of occasions offered to carry out additional noise monitoring at Mr. Rush's property, as well as asked him to complete noise diary sheets. As yet, Mr. Rush has not taken us up on that offer. He's confirmed by email that he does not wish us to undertake any further noise monitoring within his property, but would rather us rely on historic evidence that was obtained in 2020. Clearly, we are unable to do this.
Mr. Rush, did you understand the reply from the Environmental Health Officer?
Yes.
We will only consider in this hearing the evidence which is presented in your pack, not historical evidence. We're trying to establish if there is a statutory noise nuisance created by this licensed premises.
Yes.
So please, when we're answering questions, only refer to the situation as it exists just now. Yes, Ms. Goldman, you have something to add.
Yes, thank you. I wanna answer Mr. Hill because 2018, when first time he complained, first complaining first was making sure we don't have problem with shop or people. This is the one fan which is completely on top of our head constantly. When Andrew, Mr. Hill, when you came, you saw everything and you confirmed this is unacceptable because too near to a garden. One fan, rest of it you can somehow bear. Because when you close door, you still can hear. And you don't have day and night peace and quiet. Basically, when I come from work, I cannot relax in my own house because of the fan. It's one fan. About equipment, because I was doing work from home, I was there. They came 6 times. 6 times you put equipment. You know how much stress this put us through. And nothing happened after that.
Mr. Goldman, as I said at the start, there is no cross-examination in this hearing.
No, because he was
Mrs.
coming.
Goldman,
Sorry, I do apologize.
you will address the hearing through myself as the chair.
Sorry.
We have established, and I have established as the chair, I am not going to consider historical evidence. I'm going to consider, because that's what is required here, what has been submitted as a representation for a review of a licensed premises.
I understand.
So I can only deal with what the situation is now and what the evidence is.
Okay, I understand.
Historical, what happened in the past, and I'm sorry for the disturbance which has been caused to you, is not the responsibility or in the remit of this hearing. We are looking at the review of this premises, whether or not it is undermining the licensing objectives. Not hearing, not environmental health, not the state of your health, but the licensing objectives as it exists today.
Okay, thank you. Sorry, I didn't misunderstood. But why we refused this time? Because it was too long and no any result. That's why.
Thank you. I understand.
That's sorry, I misunderstood.
That's fine. I understand, Miss Goldman. Okay. Mrs. Bulbul, do you have any questions of the applicant?
Yes, thank you. I don't want to duplicate.
And through me, please.
Yes, I don't want to.
This is your opportunity to ask questions of the applicant as it exists just now before we show the videos. So is there any questions which you have of the applicant in relation to what the applicant has said today and in relation to what is in the bundle? Thank you.
Thank you, Chair. I have, Mr. Rush is duplicating what he's been saying or stating in his reports constantly. I have dealt with all his submissions in my emails.
This is not the opportunity to present your case. Do you have a specific question of Mr. Rush on what he just presented in this room?
Okay, so is he saying there's noise from the side fan? I've mentioned it in my submissions as well. We've always there's no time in winter about.
So your question is there a noise from the side fan, which is directly facing the garden of Mr. Rush's property? Is that your question?
Yes.
Mr. Rush.
But after
Mr. Rush,
9 p.m.
Is there noise from that fan at this precise moment in time? The question is there noise from that fan at this moment in time? Thank you. 24/7.
Sorry, Chair, that's incorrect.
So that's what the answer was.
That's incorrect.
What I appreciate that, but that's the answer that's been given. You'll have the opportunity, and I'm sure we'll ask questions, to state when you believe that the operating of that particular fan that is facing that property is. Do you have a further question of Mr. Rush?
Okay. Can he explain, please, why he thinks the licensing is the correct authority to be addressed today rather than planning and environmental? Why are we here today?
Excellent. I think that's a very good question, Mrs. Bulbul. Of the chair, why are you here today, and why do you believe that that single fan is causing you to call this review?
As I framed in my answer previously, I repeat it again. The licensee objective is preventing from any public nuisance, which is this presentation of this case. In regard to the fans, which is boundary invasions, and also the close to the my property is causing the public nuisance and damaging the health and well-being of myself in my own home, which is in the past 9 years, I haven't been able to use the garden or sleep or rest in my own home.
Mr. Rush, so we've established that you believe that that fan is causing a public nuisance, the one which is facing your property. Is that correct?
Yes, yes.
Excellent. That's the answer. Any further questions? Mrs. Bulbul.
Yes, I understand his concerns. At no point in time, he's saying he's made a complaint in the piece of 9 years. Has he ever approached us to discuss his concerns other than making complaints through the council, making formal complaints? Neighbours, we are person, we talk, we communicate. We're not hard people to talk to. We are approachable. Has he ever tried to come and speak to us in person?
Thank you very much, Mrs. Bulbul. So the question, Mr. Rush, is when was the last time you communicated directly to the licence holder in relation to this single fan that is facing your property?
On the
when it took through me, please.
On the July, before I actually submitted this.
July of this year.
Yes. Before I
On
submitted.
what date, please, and what was the method of that communication?
The date, I believe it was Tuesday or Wednesday. I'm not recollecting the exact date, what date was. Day was. The date.
What was the nature of the communication? Was it by email, face to face?
No, face to face. Face to face.
And where did that meeting take place?
In the shop, in the
And what did you have to say then?
I said, can you turn it off, the fan, just give us a break.
Any further questions, Mrs. Bulbul?
Any further questions? So he's also referring to some noise measurements. What kind of equipment and where has he obtained this equipment from?
Mrs. Bulbul, we've got that already in the pack. That's not necessary for the question which we have before us in relation to this particular fan. Okay, we've already established from the environmental health officer that they've offered to put their equipment in so they can gather evidence which we can actually consider as something which is the responsibility of environmental health for what they call a statutory noise nuisance. To my view and my understanding is that equipment which measures outside of the environmental health is not something which could be submitted as evidence for statutory noise nuisance. And I would encourage anybody that is experiencing a statutory noise nuisance or believe that they are to work cooperatively with environmental health, because that is their function and that is their role in legislation. So I don't think that's a relevant question for this hearing.
I completely agree with what you
Any further questions, Mrs. Bulbul?
Can he define what a public nuisance is?
Excellent. Mr. Rush, what do you define a public nuisance?
Right.
A public nuisance.
A public nuisance. The frame of the public nuisance basically is added up under the 1990 Environmental house, any nuisance disturbing or causing any damages to the individual's house, and the neighboring or any customers or anybody obviously been disturbed by that noise, which is under the operations of the individual, it become the public nuisance. Now, that is got the boundary of the peak time and off-peak time, which is been set under the environmental, what the level of the noise is going to be. Now, when that becomes...
Thank you very much, Mr. Rush. So my follow-up question to that is, why did you not allow environmental health to measure it based upon the legislation which you've just given? So the question is, why did you not allow them to measure it?
I understand. I allowed because of that, the first initial complaint to the environmental. The reason the time taken by the Mr.
By that, are you talking about in 2018?
18 and
okay, we've already established that I'm not considering evidence, historical evidence from 2018.
Can I? Because the environmental used the wrong legal test. Under the statute law, basically the legal test is come under the statute nuisance 1990. Under the licensing test which is the operational of the premises. Now, back to the question why I refused.
Mr. Rush, that is the question I want to have answered.
Yes.
So please answer the question as it exists just now. I don't need a history of what happened in 2018. This hearing is here to look at evidence which is presented in this hearing based upon what nuisance there is just now. My question to you was recently, why does environmental health report to me and report to this hearing that you refused entry for them to do their job?
Yeah, the reason refusal, because they didn't consider the nuisance is based from, which is the mechanical ventilation is using. Now, they measure only the level of the noise, not the cause of the noise. And this equipment and everything what they want to actually measure as the nuisance or statutory nuisance come from the source creating noise. Now, this establishment after when they're coming back to try to actually restore the noise equipment recording, they don't follow the procedure after the finding the cause of the nuisance. They just want to record in a surface what the noise level is. So that doesn't help my complaint, because I want to find out.
Mr. Rush, what do you believe the cause of the nuisance is?
The illegal.
What do you believe?
The illegal implants of the mechanical ventilations unit.
So the mechanical plant is the cause of the noise nuisance.
Of course it is.
Excellent. Okay, we've established that. We're not here as a licensing committee to consider mechanical plant.
Well,
we can't.
Yes,
we can't.
Can I say that?
No, you may not, Mr. Rush, right? Because you've established what you believe to be a public nuisance. You've read the legislation. You said that it's causing you personal harm. Yes. And now you're questioning the environmental health for wishing to measure the cause of the noise, which is the plant itself. And now you're wishing to actually consider it under licensing legislation, because that is not the cause.
No.
Mr. Rush,
it's misframed.
What do you believe the cause of the noise complaint is?
Unlawful installed mechanical plant.
Unlawful installed legal plant. Mr. Rush, we cannot consider that in this hearing.
Why not?
Because this is a licensing hearing.
Yes.
That is a question for you to have with environmental health.
I can.
Mr. Rush,
can I?
I've ruled on this. We will not consider it.
What is the licensing condition?
Mr. Rush, you said what you believe public nuisance is. I'm telling you now, it's something that we can't consider under the Licensing Act. That's why we're here. This is why you asked for the review.
Right.
I don't deny for a second that you may be experiencing statutory nuisance, but statutory nuisance has to be measured by environmental health.
Yes.
That is the correct route. Mr. Rush, I don't think I have any further questions for you at this time. The applicant, do you have any further questions for Mr. Rush?
One more question.
Mrs. Bulbul, do you have any further questions
That's
for
absolutely
Mr. Rush?
fine. One more question, just out of interest. How many complaints does he make, not just to us, generally?
That would have been a question for our licensing officer. You had your opportunity, but perhaps the licensing officer can, or environmental health can give us a ballpark.
Allegations in terms of sexual nuisance is from Rush.
But has,
I can't comment.
that's fine.
You've received your answer to that.
Can I
Any
ask
further
a question
questions?
to Mr. Hill in relation to what you
To me, yes.
So has statutory nuisance ever been, is there evidence of statute? Has he confirmed? Is there a report to say there's statutory nuisance? I believe there isn't, but can he confirm, please?
Just wait one moment. So I believe in the pack, and if you'd like to expand upon it, because there was instructions given to the premises for the relocation, and also there was instructions given, I believe, for acoustic box, and also for, in fact, if you want to expand on what instructions were given to the licensed premises, please.
Thank you.
If a statutory noise nuisance had been established, the council would have a legal duty to serve a noise abatement notice. So a number of noise recordings were undertaken, a number of site visits were undertaken. We were unable to demonstrate a statutory noise nuisance. The advice given to Mr. Ball, to yourself in 2020 was in relation to, that was advice. I do remember saying that I had no legal justification to require you to undertake the works. It was just advice. What we tend to do is, part of our role as environmental health officers is also to assist businesses to effectively engage with the local community. And in my experience, I felt that at the time, had you taken the decision to install additional mitigation, such as an acoustic enclosure, that may have resulted in the issue. But to be clear, that advice was not legal advice. That advice was not based that was not advice asking you to comply with the noise abatement notice. That was informal advice.
Thank you very much, Mr. Hill. You have a follow-up question, Mrs. Bulbul? Do you recall that advice? And what action did you take on that advice?
We actually spoke to our builders at the time.
Excellent. Can I, when we come to your presentation, can you ensure that you let the hearing know in this public hearing what action you took upon that advice from environmental health? The licensing officers, please.
Sorry, I just thought I'd clarify a couple of points for the committee. There is a clear distinction between a statutory noise nuisance and public nuisance that is being dealt with today under the Licensing Act. So a statutory nuisance under the Environmental Protection Act, which is what Andy Hill's predominantly dealing with, is something that must be prejudicial to health and impact on how people live within their property. And that's dealt with under the Environmental Protection Act. The Licensing Act does not require us to prove statutory nuisance, but ours is a much broader definition, and it deals with how the licensed premises is being operated. So is noise coming from the premises? Is there a failure in the operation of the premises that is therefore negatively impacting on the residents? And the noise has to be directly linked to the licensable activity. So in this case, I've just thought I'd clarify for members, you are dealing with a single noise compressor refrigeration unit to the side of the premises in the vicinity of Mr. Rush's premises, and you need to determine whether that unit is directly linked to the sale of alcohol off sales and whether there is an issue with that unit.
Excellent. I will ask that question of Mrs. Boo Boo when you actually do your presentation. I did have one further question for you, Mr. Rush, before we move on to the premises representation. Oh yes, relating to the shutter. So what is the shutter that you refer to, and what is your complaint for the use of the shutter?
Thank you, Chair. The shutter is a safety back door of the premises, which is at 11 o'clock when they're closing it. Is basically the metal safety shutter when they're pulling down, or in the morning when they're opening up, is a metal impacting each other and causing the massive noise shock, basically on the early morning, like at 6:30.
The nature of the shutter itself, I understand. So it'll be a roller shutter and it's there to provide additional security for the access point of a door. Is that correct? Yeah. Excellent. Okay, so what's your experience of when that shutter is actually operated, both for opening up and for closing, please?
Well, in the morning when you're in deeper sleep, basically when the shutter is open, is causing the sudden noise, which is
at what time, please?
6:30. They open in 6:30 in the morning.
Is that every morning?
Every morning.
And what time in the evening?
They closing 11 o'clock.
The shutter is closed at 11 o'clock?
Yes.
Every evening?
Every evening. Sometimes it's about 5 past, but they around the 11.
Thank you very much, Mr. Rush. Any further questions from the subcommittee of Mr. Rush? Any further questions from the applicant of Mr. Rush? Any further questions from the environmental officer, Mr. Hill?
Thank you, Chair. I'd just like to get some clarification on some of the submissions of Mr. Rush. So in Mr. Rush's submission, he makes quite a bit of reference to heat and odor emanating from the plant. Can you just expand on that? Because I failed to understand how this plant could emit heat and odor.
Right.
And sorry, I've got a follow-up question for that as well. You also, and also just to clarify for the committee as well, quite a few reference has been made to extraction units. And this is not an extraction unit. So this is primarily this is a condenser unit for to condense air. So there should be no extraction of air from within the premises. Primarily its function is to serve the refrigeration units.
I explain that. Okay, the unit as you present,
yeah,
they are after sorry, the presentation after that question, obviously, the extractors, they are called heat pump. Basically is for a refrigerated cooling system, which is connected to any facility they want to use, like a fridge or chiller or something. The heat pump basically creating the mechanical side of it, like a normal fridge, is the engine basically compressing the air through the system pipe to the fridge, and at the same time vacuuming the hot air from the thing, which is the fan. Is purpose of the fan that's blowing the hot air toward my garden. That is the reason of the hot air and fumes, which is yourself when in the early stage when you visited and you said you felt the smell.
When you say fumes, do you mean smells? What type of smells?
Yeah, the burning smell.
The burning smell.
Yeah, overheated.
From the heat.
From the heat, yeah.
Thank you, Mr. Rush. Mr. Hill, does that answer both your questions?
That answers my questions. Yes, thank you. I think in terms of providing my professional judgment, in terms of it's highly unlikely that the hot air that you refer to would ever meet a definition of a statutory nuisance or indeed odor. I believe if there were any sort of if the odor that was coming from the units was such that it would create a statutory nuisance, it's quite likely that the units would be heavily defective.
No, you're wrong.
Thank you for clarifying that for me.
Mr. Rush, please. We're here for a hearing in public, which is streamed to the public, to listen to your review, which you have requested. Everybody gets the opportunity to speak. and all questions come through the chair, and there will be no cross-examination. And that includes comments on a difference of opinion as regards what's there. So thank you very much, Mr. Ross. Mr. Hill, would you like to repeat that last bit, please? In relation to the equipment would be heavily defective if it was producing
I think in terms
heat
of
and smell.
if the odor Mr. Rush complains about is such that it would meet the definition of a statutory nuisance, and we need to also remind the committee that the whole reason is we're talking about statutory nuisance, we're talking about the Environmental Protection Act, we're not even talking about the Licensing Act. However, if the odor were to be such to meet the definition of a statutory noise nuisance, it would need to be quite bad from these sorts of units, and to the extent it's quite likely that the units be quite defective. And so it's, in my professional opinion, it's highly unlikely that the odor from the units that you mentioned would ever meet the definition of a statutory noise nuisance before. If it did, it would probably be quite defective, and we'd.
Any questions from our legal officer?
No, Chair, but I'd just like to touch on public nuisance, please. So a lot of the comments have been on statutory nuisance, which is we're dealing with public nuisance. Statutory nuisance can be quite wide-ranging. Public nuisance, just for clarification, is nuisance that affects essentially more than one person. It affects a wider area. So you could anticipate. So you could have, I don't know, example would be, I suppose, smoke or something like that. But the thing is, it's not confined to sort of one. It doesn't affect just one individual. That would be private nuisance. That's all I want to say.
Thank you very much, Mr. McDermott. Mrs. Bulbul, would you be kind enough to do your...
Did you want to look at the video? Sorry, before you...
I do apologise, Mr. Rush. Would you, as the licensing officer said at the start, you'll be guided by yourself. Would you like to show your videos as part of your representation? Would you like to do that now? The video evidence.
Share the licensing officer. Show them.
That's right. The licensing officer is awaiting your instruction if you would like to show them.
Yes, I will do that. I've got the video as well.
You should go there.
Oh, you got them up? Okay, thank you.
Providing explanation if members require. I'm just going to show them as they are. Bear with me, please.
Mr. Rush. questions from the subcommittee on what we've seen?
No, there's no question.
I have a question for you. So we've seen some videos there where the other bits of plant were there in the first two videos, 1 and 2. So my question for you is, when were those videos taken whereby that plant was still there?
It's been taken since basically environmental engaged with the complaint, and submitting those videos as evidence has been almost about 2024.
2024.
Yeah.
Okay. So the night ones is very difficult to see if there was a plant there, but when we move on to video 7 and video 9, we see that the plant is missing. When were those last videos taken?
They are all under the consecutive time, which is basically.
It can't be physically taken at the same time, sir.
No, it's not the same time.
My question is, when were those ones where the plant was missing? When were they taken?
They are about 24, 25.
Don't
Yes.
understand the question.
You say when they've been taken? What do you mean I can't understand?
The-
No more,
Ah,
that
okay.
video been taken. Yes, they are about around the 25, 24, year 25, 24.
Mr. Rush, have you submitted any videos that were taken this year and within the
Yes,
last 2 months?
Those dark,
Which particular video was it?
those dark one, which is you cannot see the fan himself. They've been taken recently because under the statement, they're closing 9 o'clock. I can prove that's for evidence to prove they are operating till.
Mr. Rush, what time were those videos taken? So they were taken in the last 2 months,
Yes,
and what time were they taken?
about 10:30, midnight.
About 10:30 or midnight, which?
Oh, sorry, 10:30.
10:30
Yeah,
in the
yeah,
evening.
Because it's 11 o'clock, they're closing anyway.
And they were
It's not the
taken
midnight.
in either this month, July, or in June. Is that correct?
July.
July.
Yeah.
$22.30. Yeah. Any questions on the videos that have been submitted from the licensed premises?
Oh, sorry, because we can't physically see what times the videos were taken, does Mr. Rush have any videos where there's noise from fans over, but go beyond when we're closed? Because at one point he said midnight. That can't be correct.
That was a mistake.
Oh,
Sorry,
that was a mistake.
incorrect,
Sorry.
yeah,
Okay.
sorry.
Was there any videos, recordings after 23?
Mr.
Yeah.
Rush, do you have a timestamp
Yes.
of that fan running when the video was taken and at what precise time it was taken? Because if you're presenting this as evidence for it running outside of the licensable hours, then we need to know that information.
Yes,
Please.
if you ask the technical department, basically every video, you got the timestamp on the front, date, year, and the time
Mr.
being
Rush,
recorded.
This is your evidence that you submitted.
Yes,
I'm
yeah.
asking you
Yes.
for the date and time of the video which was taken in the dark when there was no other plant there, apparently. What is the date and time stamp for that video? Because the question from the licenses premises was, is it after the hours of operation of the Premier store?
Yes, I can actually give a clear time for it. The one was 2026, 22:30, the one of them, the dark one. Yes. What it does.
What does it say precisely on the file?
Yeah, is it IMG? IMG 2026 23:30. Sorry, 22:30. the timestamp. 2026.
22:30.
Yeah,
Half past 10.
22, about 10:30.
Oh,
What
date in there?
date I cannot say the date. Yeah, I need a stronger glasses to see that. 2026, 06. Is it 06? Yeah.
6th of July then.
Mr. Rush, okay, you've presented that as evidence of what we've established is not a public nuisance, but is a private nuisance to you, because we've heard that already. So the definition between public nuisance and private nuisance. So that is the nuisance which you are complaining about at this precise moment of time.
May I answer that question? You taking that as a public nuisance? I'm not publishing that evidence under the public.
But you've submitted it.
Yes, I submitted for the different purpose of the evidence.
Yes.
Is the evidence of
As the cause of the nuisance that you are experiencing. That's your own words. You wanted to understand what the cause of the nuisance was. And the cause of the nuisance appears to be that piece of plant equipment facing your property on that wall of the Premier building.
That's correct.
So that is the cause of the nuisance.
It is a cause of the
And
nuisance.
that video taken at night in July of 2026 at 22:30 is the evidence of the nuisance.
Yes, but
That's the cause.
That's for different. Yes,
That's the cause.
that's for different
Excellent.
purpose. The evidence for different purpose.
Do you have any evidence of the shutters opening and closing, please?
I cannot access the shutter because shutter is on the hidden.
Do you have any video or recordings of the shutter opening and closing, please?
No.
Thank you. Any further questions from the environmental health officer or licensing?
No, Chair. I think the questions I had, which were in relation to when clarification when the videos were taken, Mr. Rush did provide that to yourself. So that was the only question I had. It was just clarification of when the videos were taken, and that's been answered. Thank you.
Just one question, Mr. Hill.
Yeah.
Have you seen these videos prior to this hearing?
I had a look at the videos this morning. Yes.
Yes.
It was very unclear on the videos in terms of the time stamp when they were actually taken. So, but I had seen them prior to this hearing. Yes.
I appreciate your diligence on that, Mr. Hill. You something further to add?
Can I just confirm as well? There was a video in one of the videos, which I believe you said was taken in 2024. There's quite an audible squeaking sound in the video. Squeaking sound. That's the only way I can describe it.
And it's all machinery.
Yeah. So when was that? So was that taken in 2024? That video?
What do you mean?
Can you clarify which? So the video. My understanding, Mr. Rush, is that the videos that you submitted, which are the most recent videos, showing the most recent fans, is the ones at night.
Yeah.
Is that correct? So the video, it might assist the committee then if you maybe played video 7. Yes. So can you confirm when that video was taken?
They are basically taken through the period of the 24, year 24, year 25.
Okay.
Yeah.
Okay. So so to assist the committee, even though there's quite an audible squeak in that video, that's not a reflection of the fans operating today. And that was really a missed opportunity for us as environmental health. Had you engaged with us at that stage, we would have been able to investigate that. But that's no longer the current state. So, which is a shame, which is a pity.
No, the machinery is
Mr. Rush, through me, please.
Sorry, Chair. The machinery constant is in use. It doesn't matter when or what time.
I think the point Mr. Hill is making is because you may have missed it, but the subcommittee hearing members here heard it, is that there was an audible squeak from that piece of machinery.
And it is now.
And that could be considered to be a personal nuisance.
No, I
don't. No, but we cannot hear. You say that is as it is just now, but we do not hear that audible squeak from 2024 in the equipment which we saw in the dark, which you yourself have said was taken in this month of this year. There is no squeak there.
Yeah, that.
Mr. Hill is making the point.
What?
Mr. Hill is making the point. That was an opportunity for a personal nuisance
Yeah.
to be logged.
Can I ask the chair, please frame the questions and answer and your considerations clearly for those evidence that have been presented. The one in the dark, I just mentioned that's the reason for purpose of that piece of the evidence. For a statement made by the shop owner, the fan is off 9 o'clock, but the time shows it's operating to 22:30. That's only purpose of that piece of evidence.
Mr. Hill, I see you getting a little bit agitated.
No, I'm not.
Mr. Hill, we have met, sorry, Mr. Rush. Mr. Rush, I see you get a little bit agitated, but what I've done is I've made a note of that evidence. We're now referring to video 7, which you presented, which Mr. Hill saw prior to this meeting, where he describes a squeak. That video was taken in daylight. Mr. Hill's point, which he presented, was that was an opportunity to you as the resident to make a personal noise complaint because it was creating a squeak. The recent ones taken in the dark have no such squeak. Do you agree or do you disagree?
I disagree.
Okay, thank you, Mr. Hill. Sorry, Mr. Rush. Mrs. Bulbul, this is your opportunity now to make your representation to the subcommittee. Thank you.
Thank you, the chair. One more last question I would like to ask Mr. Rush, if that's okay. Is that okay?
As long as it's pertinent and will help the subcommittee in their deliberations.
It's so the video, all the videos, I've watched it carefully. I've listened to them very carefully. Actually, he's only referring to one fan. Is he aware that's a soft drink fan, and we're here as a licensing review?
Mrs. Bulbul,
does he have any other videos?
Mrs. Bulbul, that was one of my questions, to establish what fan it is, as was guided by the licensing officer for what, as a hearing, we are here and allowed to consider.
Okay.
Right? So you're stating that that fan is actually for the refrigeration unit for soft drinks only. Is that correct?
Yes.
Excellent. Thank you very much. You want to present your representation?
Yes,
thank you.
Thank you for allowing me to speak to you today, and I do apologise on behalf of everyone, public as well, for wasting your time, my time, Wayne's time. I know you're quite a busy guy dealing with premises, dealing with 1,000 shops. Anyway, sorry. We take our responsibilities as premises holders very seriously, and have always sought to operate our business in accordance with the conditions of our premises license. We've been operating for over 20 years and have never had any issues or disputes with anyone, public, neighbour, regarding license whatsoever. I read. Thanks for Mr. Rush for preparing long reports in relation to submissions. I have read them very carefully. I just don't want to duplicate. I believe I've responded them in detail. I don't want to duplicate and take up your time of what I have said before. So I believe you have read all my replies carefully as well. So we're here today. I trust you as the committee will consider the evidence, available evidence objectively, and will determine whether the licence objectives of preventing public nuisance have actually genuinely been undermined. The review is primarily based on allegations concerning the external fans. However, I believe it's actually important to distinguish between a neighbour's dissatisfaction, as we are seeing here today, and evidence of that our premises have actually been operating in a way that undermines the licensing objectives. I can't see, there's no evidence before the committee that our premises have operated in a way that we have deliberately caused nuisance. I think there's been a confusion in relation to what's happened at timeline, what's actually, because Mr. Rush has been, as he said, making several complaints throughout the years. So when Mr. Rush first complained, I think it was 2018, we moved the dairy fan so it was on the site. All the fans were on the site. So I've got the current situation of the fans here, and this one, we've only got 3 working current fans at the moment. So all the fans were on the side facing the property Mr. Rush is living in. I understand he's a ground floor resident. So when he first initially complained, the only fan that's on for 24 hours is the dairy fan, which you would appreciate. We need it on for that amount of time due to the storage, dairy, milk, which needs to be safe condition for the public. So we've moved that dairy fan to the rear, and which I've got the current situation, location. So that's the dairy, which I believe it's on the bundle and on the website. That's the dairy fan. Then Mr. Rush continued to make complaints. So we thought maybe that's still causing discomfort to Mr. Rush. So we've actually replaced the fan with a new one, even though it was working, because obviously technology changes. There might be better fans available to eliminate noises. So we've replaced the dairy fan with a new one. So the following year, I can't remember if the complaint continued, but we were making some changes to the shop. So we replaced our alcohol refrigerator, and at the same time we changed our fan as well, together with the alcohol fan, alcohol refrigerator. So however, the soft drink, which is this one here, remained because it was on for limited hours, and you know how it's like in the UK. We don't have much hot weather for it to go on for longer hours. So for sake of us, for our utility bill as well, we always turn it off at certain time. And in winter times as well, we actually keep it on only for a few hours. I wouldn't be able to give you exact times and dates, but that's the general practice of what our business does. We don't keep it on for the whole duration of our opening hours. So that stayed on there. So yes, I do. Mr. Hill did mention about a acoustic wall being discussed. Yes, it was discussed, and that was one of your questions for me to address. We did discuss it with a builder at the time, and our builder confirmed that the roof, you can see this is actually a roof. That's a roof, that's not a ground. The roof would not carry, it wouldn't be safe for both, suitable for both buildings. So that's our tenants above the shop. That's the flat above the shop. That's the roof to our storage room, and that's the property where Mr. Rush lives in. So I believe he's the ground floor flat owner, and there's other tenants directly. And there's a window there, because I actually used to live at this property about 10 years ago. So I know how that area, like I've been on that roof before. So there's actually a window there as well. So our builder said it wouldn't be safe for both buildings, so we kept it as that. And no, we after discussion with Andrew Hill, it was left as that, and we've never heard back. Occasionally, yes, Mr. Rush did make other complaints, as in he continued complaining, but it wouldn't be direct complaint to us. It would be either shouting through the door saying, turn off your fans, or even on one occasion, I did submit in my statement as well, he argued with one of our workers on a bus. This is not acceptable, and I would not accept it as a employer as well. This is not how you put your frustration across. You can maybe come and speak to us. Yeah.
You're presenting to the subcommittee hearing, not to.
Okay, I do
Mr.
apologise. So yes, the chair. So that's how we as humans do speak, and we would want to hear his concerns, discomfort face to face, but we've never had that. Also, I don't believe the Licensing Act is actually intended to resolve every neighbour dispute which we are having here. We believe the Act requires decision to be based on evidence, and the actual independent evidence we only have is we don't have any independent evidence other than the videos of what Mr. Rush has provided us with, and that voice notes, that videos only refer to, actually only relate to the soft drink ban, and we're here in the licensing committee. So there is, that's why I don't, also he refers to some smells. I can't also find anywhere or any evidence, or don't understand what smell, as Mr. Hill has mentioned before as well, what he's referring to, what kind of smell. If it's a burning smell, I know he's mentioned that there's burning smell. I suspect, as public, as neighbours, we call fire brigade if he believes there's burning or there's danger. So yes, the videos notes he's provided our soft drink fan, therefore relate to an equipment that operates independently of the sale of alcohol. If there are concerns about noise from equipment, there are other statutory regimes as environmental protection. There's planning legislation specifically designed to deal with such matters. Licensing Act should not duplicate those controls unless there is clear evidence that our licensing objectives are being undermined. We operate responsibly, complied with our license, and have sought to be good neighbours with everyone. There is no pattern of crime. I'm going to read out our objectives. There is no pattern of crime or disorder, no issues relating to the protection of children, no evidence that the operation of our license, of the licensing activities themselves are causing public nuisance. I therefore resubmit that the evidence we have in front of us does not justify modifying our license or imposing additional conditions. However, if the committee consider that Mr. Rush's concerns remain, we are willing to continue to work with, for example, Andrew Hill or other environmental officer, environmental health officer, to resolve any action that can actually benefit for both parties. For those reasons, I have made all my submissions very carefully in an email. I'm not going to, as I said, I'm not going to duplicate what I've said before. I've dealt with all his allegations in detail as well. So I asked the committee to dismiss the review and allow the premises license to continue to unchanged. Also, if that's okay, I would like to read out an email which deals with...
Mrs. Bulbul,
yeah.
Is that actually in the pack?
Yes.
Can you tell us what page it reads?
No, it's not in the pack, sorry. It was sent...
I'm sorry, we can't accept that at this hearing if it's not in the pack. I'll just get legal advice on that.
concur with that.
You may read it out as part of your representation.
Thank you. Mr. Rush, on last Friday, we received an email from Tanya at 8 p.m. at night on the Friday, sending us across Mr. Rush's final statement, final submissions. I have prepared an email, but I understand it was too late in the process to be included in the bundle, so therefore I would like to read it out. It was actually sent to Tanya. She'll be able to confirm as well. With regard to Mr. Rush's submissions received on the 17th of July at 20:03 p.m., we would like to state the following. Mr. Rush submits that any noise from refrigerator fans fall within licensing. However, Mr. Rush needs to appreciate that the Licensing Act is concerned with the effect of licensing premises on the licensing objectives. There is no evidence that the fans, as operated on limited hours, I have mentioned it in my previous emails as well, on what times.
Just for the clarification of the subcommittee hearing panel members here, this is an email that you're reading out, which you sent to the licensing officer. Thank you. It's not from a third party.
No.
Thank you.
So I'll call them public nuisance connected with the licensable activities. The document repeatedly states that statutory nuisance is not required. This may be correct, but Mr. Rush still needs evidence that the licensing activities are being undermined. Simply asserting that the fans produce noise is not sufficient. There is no acoustic report showing unacceptable noise levels other than videos Mr. Rush has taken. Mr. Rush argues that sportive neighbours are legally irrelevant. Although we are not conducting a popularity contest, evidence from neighbouring residents that they have not experienced any noise or smell is relevant factual evidence when assessing whether public nuisance exists. Mr. Rush relies on the case of Hope and Glory. We've got our legal advisor here to advise on the actual correct interpretation of the case as well. So the league on this, but my interpretation of the case does not prevent the committee from considering evidence from neighbouring residents who have experienced no nuisance. The case confirms that the committee should consider all relevant evidence and determine what weight to give it to. The existence of only one complainant does not automatically prove public nuisance, just as the absence of multiple complaints does not automatically disapprove one. We believe the committee will assess all the evidence in relation to this. Mr. Rush also relies on the Waite's case to say license is preventative. Again, we've got our legal advisor to confirm, but my interpretation, we do agree with what Mr. Rush, how he's interpreted the case. However, prevention does not remove the need for evidence. Environmental health has not identified a statutory nuisance, as we've heard. There is no independent report demonstrating unacceptable noise levels, and there is evidence from neighbouring residents that they have not experienced nuisance. We also note Mr. Rush's interpretation of the section 182 of the guidance as well. He is correct in submitting that public nuisance under the Licensing Act is not identical to statutory nuisance under the Environmental Health Act. However, the absence of a statutory nuisance is still relevant evidence. Or, as I said, I'm not in a position to interpret the acts, the cases. If I'm wrong, obviously a legal advisor would be able to quote me on this. Also, in the last email, he's referring to our statutory declaration, which we've provided.
Mrs. Bulbul, are you continuing to read the email, or?
I am reading at the same time adding bits.
Excellent.
Okay.
Might I suggest that you'll have an opportunity to sum up directly after we've asked questions of you for any points which you may have missed. Thank you.
Okay. With regards to the statutory declaration, this was provided to the planning department to confirm the enforcement period. We have never been advised or aware that planning permission was required to have fans. However, as installation was beyond the four-year enforcement period, we provide the statutory declaration to the planning department in this regard. There was no deliberate intention of providing the statutory declaration late in the process, as we believe this was purely relevant to planning and not licensing. However, we later decided that the committee may want to see it, read it in advance of the hearing on Tuesday. So my previous correspondence referred to this statutory declaration as well. So it wasn't that. I hope this deals with Mr. Rush's final submissions. Thank you, Baha Bulbul. That's what my email said, sent to Tanya, our licensing officer. Yes, so if you've got any questions, I'm here to answer. Thank you.
Just to reassure you that everything which is said in this room will be taken into consideration when we're doing our deliberations, as will all the written evidence which has been submitted. Do we have a point from our legal officer?
Mm-hmm.
Basically, the case was basically says that a licensing authority or magistrate can't entitled to simply ignore the guidance of the Secretary of State. Don't have to work slavishly through it. That's basically what the case is about.
Thank you very much, Mr. McDermott. Questions of the premises from the subcommittee, please. Councillor Bartlett.
Thank you. Just for absolute clarification, the fan that points directly at the Mr. Shaw's property, that is connected to the soft drinks cabinet. Okay. The three others around the corner on the other wall, there are 3 units there. What are those 3 connected to?
There were 3 about a month ago or so, but one of them was not working. It was just there. But having liaison with planning department, and we were advised to remove it if it's not working. So the current ones that are, this is the current situation of the rear. So there's dairy at the top, and there's alcohol at the bottom.
Okay.
And what? Sorry,
yeah. So okay, so you're left with 2.
2 at the rear. Yeah.
And what do those 2?
Dairy refrigerator, and the alcohol refrigerator.
Okay, so one of those units does feed the alcohol storage.
Yes, correct.
Refrigerator. Okay, thank you.
Yes, absolutely.
Mr. Hill, can I just come to you on a point you made earlier on? You said that it was unlikely that those units on that elevation would be heard in the adjacent properties. They're very close to the boundary, even though they're not as close as the one on the adjacent wall. Is that just your assessment, but you haven't got anything to substantiate that?
Yeah, my understanding is that the elevation where those units are located is quite some distance from Mr. Rush's property.
Correct.
And in terms of the direction, so the units are, so the noise would propagate outwards, and it's a direct right angle to Mr. Rush's property. So any noise propagating outward, it's very likely that the majority of the noise energy will be in the opposite direction to Mr. Rush's property. So
Because it's not, and I would say that those units are only a matter of meters away. They're not a long way away. So is it conceivable that when the wind is blowing in the right direction, that the noise would carry into the adjacent property?
it is conceivable. It is conceivable if the wind is in the right direction, then some of the noise could potentially be blown into that area. However, we need to consider that is the noise from refrigeration units is very typical of this type of business. So yeah, to answer your question, it is conceivable that noise in the right wind direction, some of the noise energy could potentially be blown into that area. But absolutely not. No. Absolutely, yeah. Absolutely. Yeah. And I think it's worth pointing out as well, if it assists the committee, that the noise measurements that are referred to in the report, although they go back to 2020, I believe, when they were first taken, there's been a significant change in the noise character in the area, in that a few of the fans have now been removed. So yeah, and although we can't really compare the noise measurements from 2020 to the current situation, I think indeed in terms of the noise character of the area would have changed significantly, because a number of the noise sources have now been removed.
Thank you.
Just before we give Councillor Chapman Law an opportunity, so I just want to nail this, the fact that on the street view, which I mentioned earlier, so you said that the dairy fan was moved and it's a 24-hour operation fan. On the street view from Google View or Google Maps in 2019, we do see a fan appears when there's no fan there in 2015. So that's the dairy fan, yes.
Right.
And did you say that that was upgraded or replaced, or was it simply moved?
Upgraded.
Right. So
But we initially,
it was upgraded, or e.g. replaced, or
basically the one that we had on the side that was moved.
yeah.
It was just moved. It was the same one. Then when the complaint continued, that's
Yes.
when it was replaced.
Right.
With
So in 2019 that happened. So it was moved and then it was replaced. Okay. Thank you very much for that. Sorry, you got a question?
Yeah, sorry. Just one more question. The fan unit that is adjacent to Mr. Shaw's property, are there any reasons why that couldn't also be moved to the same location?
Oh, well, it was on for limited hours, so it wasn't on for long hours. We didn't have any reason to believe that was his discomfort, other than because it's on for 24 hours. That's why we've made more efforts in relation to dairy, because it's on for 24 hours.
But technically, are there any reasons why technically it couldn't be moved?
Then the complaint was left as that. Then we didn't have any direct complaints in relation to that fan. So
you haven't actually considered potentially relocating it?
I did mention it before, and we did have discussion with Andrew Hill about a acoustic wall being built. However, it was just unsafe for both properties and the roof, our premises itself as well. And because if that's what our builder said, I don't think that was going to be approved by the planning department anyway. As I said, we've always had the impression that it's on for a few hours. We've never had any heat wave as we had this year. So obviously it did extend this year until we closed the shop at 11 p.m.
Thank you.
Okay.
Thank you very much, Councillor Bartlett, and thank you very much for your reply, Mrs. Bulbul. So just to nail this, just one moment, Councillor Chapman-Law, because this is important, I think, for establishing what's currently there, because the evidence which we presented is not what is currently there. So we established that the dairy farm, the dairy plant operates 24 hours a day. It was moved in 2019, and then it was then upgraded because it was still not doing what it's supposed to do. You then said the alcohol fan was moved in 2020, and in fact it was replaced. So
Yes.
correct so far. Now, the evidence which we have in our packs and what was presented, you showed a picture just now which only shows 2 fans on the rear wall of your property.
Correct.
So in relation to the dairy fan, which one has now been removed? Is it the one directly below it, or just oblique, or is it the one
That's
which is,
the current.
or is it the one closest to Mr. Rush's property? Which one has actually been removed? Because it was broken.
So can you repeat that, because it just
Okay.
this is the current situation of
That has 2 fans.
Two
Yes,
fans.
excellent. So it's the one that's directly below the dairy fan is still in operation.
Yes, that's the alcohol.
Excellent. So the one that is closest, because previously there was 3 fans on that back wall.
This side.
No. On the rear wall only.
Yeah.
Viewable to the public.
Yeah.
2015, no fans on the rear wall.
Yeah.
2019, a fan on the rear wall. That was the dairy fan in operation 24 hours a day.
Yes.
It was replaced after it had been moved, so it functioned better.
Yeah.
You then said the alcohol fan was moved in 2020.
21.
21.
Yeah.
21.
You said 1 year later. That's fine. 21. Thank you. The next picture which I have on that the public can see from the street is 3 fans on the back wall. You're now presenting a photo there, which is possibly in the pack. I must confess that I was confused with a number of photos showing different numbers of fans compared to what the public can actually see, or could actually present a public nuisance. Just one moment. You then said that 1 fan was broken and it was removed. What piece of equipment inside your store did that fan used to serve?
Would you think would be able to confirm that, answer that question? Yeah, that's no. Basically, they were. Oh, sorry, you are sorry.
So when we replaced the dairy fan in 2020,
yes.
So because of the
2019 and then 2020 you replaced it, and
Because
now
of
we're
the-
in 2021. An alcohol fan was moved to the rear wall.
the fan we see.
Where
on-
was that moved to in relation to the dairy farm, to the fan?
Because of-
Because we know where the dairy fan is. It's the top one.
Yes.
Excellent.
Because of the dairy fan condition, it was working fan. We just got the Neva model,
Yeah.
and we kept it, the dairy on.
That's the one that you.
That's the one we took it on the wall. We kept it on the side. It wasn't connected. We were using for the parts because there wasn't any problem with the fan. So we.
Okay.
Yeah.
I'm just trying to be as clear as I possibly can
That-
for the
that's the
information
first one.
which is necessary for the alcohol, the one that supplies alcohol, right? That's what we're considering as a sub-hearing committee. I see evidence on Google View that there was 3 fans on that rear wall.
Yeah.
You told the hearing that 1 was broken and it was removed. I have 2 questions. Which one was removed and what did it serve before it was broken?
I'm not sure if I said it was broken. It was never broken. It was just not connected. Sorry, is there anything I'm getting confused about?
Yeah. Okay.
It wasn't connected.
Let me rephrase it. There are 2 fans only on the rear wall.
Yeah.
Correct?
Yeah.
Currently.
Yeah.
The dairy one,
And
it's the top one.
Yeah.
There's an alcohol fan there now.
Yeah.
In relation to the dairy one,
Yeah.
is it directly below, or is it to the right, nearer to Mr. Rush's property? Which one is it that serves alcohol now?
Directly below.
Directly below. Excellent. So in question to your question, Councillor Bartlett, this van is now removed. Yeah? Yeah, excellent. So,
Can I answer something on that? Sorry. What they're trying to explain is when the dairy fan broke, instead of removing it, they left it there but not connected.
Yeah.
Because it was still working, it was still good for spare parts. So they kept it there not working and then replaced. They used it for spare parts in the fan if anything broke on the new one.
they kept it where?
On
the wall,
on
the rear wall or the
On the
side wall?
roof.
Yeah.
It wasn't on, was it on the wall?
No.
It was on the roof. It was just there because the roof, which you can see, that's our property as well. We've obviously, it was just kept there to.
For the parts.
This is not really helping. There are two fans on the rear wall, correct?
Yeah.
Yes.
Excellent. What does the top one serve?
Dairy.
Excellent. What was the bottom one serve?
Alcohol.
Excellent. Why was the third fan taken off?
When we liaised with planning, that was recently when planning said, recommended that we take it if it's not working for planning purposes. So we took it out. Even we just removed it. It wasn't connected anywhere, so it wasn't doing any purpose. We were just kept it there just to use it as spare parts if anything happened with our current ones, because you would appreciate it's quite expensive to buy new parts. And no.
No. Yes.
Yes. Yes.
Dairy?
Correct.
Got one, the alcohol.
Yes.
Correct.
The last fan, which is in question now, is one which is on the side of the property, and it only serves
Soft.
soft drinks.
Correct.
And by serves, I mean services it.
Yes. Correct. Correct.
Excellent. So now, hours of operation for the dairy fan on the rear wall at the top, 24 hours, correct?
Yes.
Alcohol, what's the hours of operation for that?
So just obviously we don't want to be paying too much bill as well, so we always kept 6:30 a.m. until no, off the shop, did you say? Yeah, is that correct? Oh, the
After
alcohol
8. After
of
8.
the fan, sorry. Yeah, correct.
Yeah.
Yeah. Yeah.
So the alcohol.
Yeah.
What is its hours of operation that you switch?
The alcohol one, most of the years, it's limited hours. But on the summertime, so we open it. Yeah, we open it. At summertime, we open it after 9 o'clock in the morning. Alcohol. Yeah. 9 in the morning, 9 a.m. Yeah.
You switch that on this.
Yes.
Switch it on, yeah.
What time?
We switch it off. Yeah, depends on the weather. Maximum like 10, 10, maximum 11. The closing time. Yeah.
Thank you very much. Last one.
Soft drink is again same. Most of the year is we don't use pretty much. But summertime is same as summertime's after 8. Yeah, and closing time I would say maybe a bit earlier, but
Why is that fan switched on an hour after alcohol?
sorry again.
Why is that fan switched on an hour after you switch on the alcohol? You said that you switched that one at 7 o'clock.
Because of the soft drink is the face into his flat that he lives. So we
I only want to know what time you switch it. And then I ask the question. Is that an hour later? So for the benefit of Mr. Rush, switch it on an hour later than the alcohol one in the summertime for the benefit of.
Yeah,
because
correct.
it start
Correct. Yes. Correct.
start selling early.
So that's in the summertime, 0800 for 22 hours, 2200 hours. The alcohol ones, 0700 hours,
Yes. But all,
Now, the soft drink in the summertime, what are the hours of operation for that? Sorry, you got that.
we've got-
Yeah.
Captain, Councillor Chapman. Please, ask your question.
To be honest, Chair, I think everything has been answered
Yeah.
multiple times. And I don't believe any questions I have would add anything to the conversation.
Thank you very much. So there was a question that was asked by Councillor Bartlett. It wasn't really answered. Would you consider moving the soft drinks plant to the rear wall, possibly to the position where the spare one was?
yes.
Yes or no?
Yes.
Thank you. Excellent.
Can I expand on that, please?
Please.
Yes, we will be willing to, but we will discuss that with the environmental health.
Yes, absolutely.
Thank you.
I think that's what you said in your email that you read out, that
Yeah.
you're willing to
We are
work with
willing to.
environmental health for what
But
is
this is not
what appears to be a personal nuisance,
Yeah.
not a public nuisance. Thank you.
Thank you.
Right, my last question then is related to the shutters. Yes. So talk me through your typical day for opening up. Now, I'm correct in thinking that your alcohol license is a 24-hour license in effect.
Yeah.
Yes. But what is your typical day that you're open for business?
So we open at 6:30 in the
6:30.
morning. So
At what time in the morning?
6:30 in the morning.
6:30.
in the morning.
And how? What do you open up? So is the
we've
shop
got the
open
front
to the
shutters.
public, or is that you coming in to set up for the day?
Set up. So
Come and set up.
to set up at the rear door. We've got the front shutters, which is electric, and we've got the rear entrance back stock room door, which we've got shutters. As you would appreciate, we need that for the safety of our premises.
So you open
at
the
half
rear door
6.
at 6:30.
Yeah.
The front shutter's electric at what time?
It's open about maybe
Okay.
5 minutes later or 2 minutes until either Mr. Simsek or Mr. Bulbul opens up. Sure, how long it takes for them to walk from the back door to the front door.
Excellent.
There's no other.
The hours of operation that is the public have got access to your store is what?
Until 23.
Yeah.
At what time in the morning?
I would say 6:30. Yeah, 6:30.
So
Oh.
you're open to the public from 6:30
Yeah.
Same.
till
When-
2200
when
hours,
we walk from the
22
back door to
until
the-
23. 11 p.m. at night.
11 p.m.
Yeah.
Is that correct?
Mhm.
Excellent. Thank you very much. So why does the rear shutters get opened at that time in the morning? Because I take
we
it
have access
the-
to our shop.
So
Stock.
you restock at that time in the morning.
No, we don't restock it. That's how we get into the shop.
So you gain access,
We gain access at the rear.
and
we
is that
don't
the
gain-
only way to access because the electric shutters cannot open from the front? Is that correct?
Is that
Yes.
correct? Yeah.
Yes.
So it's not possible for you to enter the store from the front.
Yes, but also, do we have a key for the
Is that
front
correct?
shutter?
We've got key for the shutter.
There is only one entry to the store when it's secured for the night.
Shutter is not a problem to entrance on from the front, but the automatic door on the front side for the public. So when we lock it, so we have to open it from inside to the shop with the key. So we can't open it
The
from
door.
outside.
Oh, can't we?
Yeah,
Okay.
no, we cannot. We can open it.
Excellent. What about the operation during the day? Is that rear shutter, is it open and closed,
No.
or it remains open?
Just for
Remains open. It's only
just 5 seconds in the morning, 5 seconds
Excellent.
closing time.
And when you're closing up, yes, what's the method that you close up, please?
We close
Just run
it.
me through that.
pull it down.
For the whole store, please. How do you secure the store?
Do you want me to talk or you do want to talk?
For the rear shutter, isn't it?
All the shutter, we've got 2 shutters and we've got a fire exit.
So the front shutter we control with the control like remote control. So it's just electrics, and then we walk out the back side. We use the back door to entrance and going out. So just in the morning and the evening time. And when we lock all the doors, when we go in back side, we lock the back door and pulling down to the roller shutter, and that's it. Just same routine in the morning as well. So we're going in, pulling up to the shutter and opening the electric shutter.
Reason
what
I
I
asked
mentioned.
this question because part of the complaint from the applicant was related to the opening and closing of that rear shutter and the impact that it has on that particular complainant. So now we've established that. When was that rear shutter installed, please?
Before we took over, that was over 20 years
So
ago.
it's over 20 years and it's been the same shutter throughout?
Is that correct?
Yes, I believe. Yeah.
Yes, I
So
believe
it's a
as well.
20-year-old shutter and it's operated in the same way.
Yeah.
Would you be willing to consider with environmental health and possibly Premier Stores actually having a rear shutter that actually wasn't 20 years old and created that amount of noise? I'm not asking you for the spot. I'm only asking you, would you be prepared to consider it?
Do you want to answer? Do you want me to answer?
Yeah, it's your answer, really.
We are willing to, but we don't believe this. Well, it's not a necessary cost. Why? It's only two seconds pulling up, pulling down. Never had any issues. As I said, we've lived above the shop. We've never had any issues. Like this window, I used to live sleep on that bedroom. Yes, I'm not saying there's no noise. There is, but does it affect?
I'm glad to hear that you would consider it. Thank you very much.
Thank you very much.
Councillor Bartlett, any questions? And Councillor Chapman-Law, you've made your opinion clear. Mr. Rush, any questions of the presentation by the premises, please?
Yes, Chair. I would like to ask the premise holder, obviously, when they installed those industrial size machinery, do they apply for planning permission first?
That's not something we can consider here in this hearing. We've already established that we would not consider planning matters. Thank you very much. So what's your question when they installed it? Because we've already heard that the rear shutter, which you've made the complaint about, has been in there since they took over in 20 years ago.
I understand that, but my issue is part of the shutter himself, the mechanical plant, the extractors. The purpose of the questions I asked, when they install those mechanical, and
do you have a question
yeah.
of the representation that was given? The shutters question, yes, you asked the question as regards when they installed, did they require permission?
Yeah.
Okay, the answer is, I anticipate not. Next question, please.
Okay, next is what's the purpose of the, obviously, they plant those mechanical extractors back of the building instead of in the front of the building, which is in the public highway. They got a clear space for it. What's the reason they hidden those machinery in back of the building?
There is no equipment hidden from public view with the exception of a fan which serves soft drinks refrigeration. There is no fans which are hidden from public view with the exception of that fan.
Yes, the public view only that too, which is soft drink and the alcohol and dairy, as according to your presentation, is with the Google map, you can see that. But the issue is causing
Excellent. Thank
the
you.
soft drink.
Thank you. I've got it. So the fan, which is on the side of the property, rather than the rear, which you had a bedroom window above or a window above for the flat where you were at. Yes. So what was the purpose of leaving that one there? Was the question, I believe.
I did reply to that before in my emails.
I understand. Let's just refresh it.
It's on for limited hours. So there was no reason, and also I don't. Hussein Simsek will also be able to confirm that where there's 2 fans at the moment. I don't think it would be safe to have another fan in on that wall. That's obviously planning will be able to confirm.
Okay, that's not the question I asked. I appreciate you expanding on that, but to be honest with you, you had a spare fan for the use of fans
But it wasn't
mounted on the rear wall.
Mhm.
Yeah, so the mountings and the fixings have already been established that they operated, or it was in place on the rear wall. So the reason for leaving it there is because of cost.
Well, it wasn't cost. Andrew Hill would be able to confirm. We were liaising with you as well at the time. We did discuss an acoustic wall. That didn't go well.
We are talking about moving the fan to the rear wall as opposed to fitting an additional acoustic shielding round it. You've already established that your builder advised that he wasn't confident that that would be necessary. We're talking about removing it I think the question, expanding on the question, is why is it still on that wall instead of one at the rear?
I can answer that.
Still, say it, Raj.
There's no legal justification for the premises to move the fan. We could only legally compel the premises to move the fan through the use of an abatement notice if we determine a statutory noise nuisance. We'd never ever determined a statutory noise nuisance, so therefore there's no legal. There would have been no at the time when we did our evaluation. There was indeed no legal justification for the fans to be relocated. I think it's also very important to point out as well that there still doesn't exist a legal justification for those fans to be relocated. I think in terms of our responsibility, if indeed Mr. Rush did offer us an opportunity to do a further noise survey, if indeed we did determine a statutory noise nuisance, all we could legally require is that they abate the noise. So they take action to prevent that noise. And that could be change in the specifications of the units. It could even be indeed limiting the hours that the units are used, which they're already doing. It could extend to an acoustic enclosure, but so we could not legally, so even if we were to serve a noise abatement notice, which I know isn't really the purpose of this hearing today, even if we were to serve a noise abatement notice, in order to require that, to comply with that notice, there are various actions they could take to comply with that, to manage the exposure of noise. I think we have to be mindful of that. These units were in existence when Mr. Rush moved into the property, and therefore to expect all the fans to be removed retrospectively is, from an environmental health point of view, it's certainly something we could not support.
So, Mr. Rush, it's not enforceable in law. The fans which have been removed so far, and I'm paraphrasing a little bit, have been at the discretion of the premises. So does that answer your question for why that fan, which serves only soft drinks, e.g. the machinery that's for keeping soft drinks cool, remains at that location on the wall facing your property? Do you have any further questions of Mr. This is the questions of Mrs. Bulbul through me, please. Through me, please. No, not the environmental health officer. Questions of the representation that Mrs. Bulbul has presented, please.
I say again that the main reason of this license review for that purpose of the soft drink extractor fan. Now, with the purpose of those two fans being relocated or reinstalled, what the purpose of, as we said, is no legal justification for that. What is the moral justifications, or as a community working together, as she said, we try to work with our neighbors. What the purpose of that? There are space which they can be easily relocate or is moved to the front of the shop in the highway. So what the purpose of the not doing that, instead of sitting here to explain the situations, what made as a questionnaire and what the reason of. So this is the question of how can you obviously morally be justified to say I'm not moving that because there is no law enforcement, where the Mr. Andrew is advise them either build an acoustic wall around it or remove it or relocate it.
Mr. Rush, I did not hear a question there. I asked you to do a question of the premises property, and you didn't ask a question. You made a statement. I've made note of the statement which you've made, and that will be included in the determination. Do you have any further questions of Mrs. Bulbul for the premises?
No, I don't have any question because that's what I said and what is the purpose of we are here.
Thank you very much. Any questions?
No questions.
Yep. So, Mrs. Bulbul, all parties will have the opportunity now to sum up. Because you spoke last, you will sum up first, and then it'll be over to you, Mr. Rush. Do not repeat in your summing up anything which you've already written or presented verbally today. It is your opportunity to raise any points which you may have overlooked or forgotten. So please sum up now.
We've been here for over a couple of hours, I suspect, and we're repeating each other. I'm duplicating what I've said before. But yeah, I'm happy to liaise with Andrew Hill or other relevant parties in relation to any recommendations. But I understand from Andrew Hill as well, there's no statutory nuisance which has been identified because Mr. Rush failed to cooperate. But if he's willing to liaise with Andrew and we can go from there and listen to each other rather than having to sit here. This is the first time me seeing Mr. Rush's face, and it's probably
Through me, please.
and Mr. Rush probably is the first time he's seen me. It's just waste of resources for both the council and us having not like this. Preparing for this has taken so much of my time. I had to rearrange my holiday just to attend this. Tanya did kindly offer to postpone the hearing, but I didn't want to because I just wanted this to be done with as soon as possible. Yes, he does mention about mental health. I'm not going to go into detail. This has caused me so much stress and anxiety. I've got a 2-year-old son. I've got a 6.5-year-old son. The emails, even this email which I've drafted, was done on my son's birthday on Friday. So I suspect it's just unnecessary. I don't believe this is a relevant place to be here today. But as I said, we're happy to liaise with the relevant parties. He keeps
Thank you very much, Mrs. Bulbul.
Thank you.
I think you've covered and made your point
Thank
perfectly
you.
clear. Mr. Rush, your opportunity to sum up. Again, do not repeat any information which you've already used verbally. Do not repeat any information which we've already discussed or has been in the presentation pack. It's your opportunity to say anything which you have neglected or overlooked saying before you're summing up. Thank you very much.
Well, I appreciate the presentation, obviously, and this committee. In regard to the evidence and what has been shown in the bundle and photograph and videos, there is a vast disturbance and anxiety going on in daily basis. In regard to those illegal fact and stages under the licensee, which is the section 2.14 and 17, under the nuisance, basically, and breach of the licensee, I asked this committee to make an order to relocate the fan, which is in questions and causing huge disturbance. And I trusted this committee, obviously, did their work in honest way and under the law, basically, which is what we requested from the beginning. We cannot stand 24/7 the nuisance of the fans, which is disturbing our comfort community that you cannot use the garden, sit in the garden on a daily basis or doing whatever, and causing a lot of anxiety and stress, wasting the time, and is running in the long period hours where the previously the shop owners basically stated that the fan is off 9 o'clock. So this whole statement is gathered the evidence of what I'm asking this committee to make an order or relocate that fan so be end of this dispute.
Thank you very much, Mr. Rush. So on that summing up there, this hearing is drawing to its conclusion. I would like to let you know what's going to happen next. This subcommittee will deliberate in private. People that will be present there is obviously a subcommittee, our legal advisor and the clerk to take notes. And then our decision will be communicated to all parties. I'll leave it to our legal advisor to point out the right of appeal by anybody that's been involved in this particular hearing.
So there is a right of appeal to the Magistrates' Court, which is exercisable within 21 days, and that's time limit starts from the date when you receive written notification of the decision that's going to be made today.
Thank you very much. I would again like to thank you all for your presence. I'd like to thank for all the work which you put into your representations, and thank you for your time today. And this meeting is now concluded.